Namaskar. We are delighted to inform Symbiosis Law School NOIDA, in association with Lex Witness, India's first magazine on legal and corporate affairs, THS, the law firm, Sadgamaya, presents the knowledge series on law and justice. As part of the series, on June 20, 21st and 28, 2020, Honorable Mr. Justice C.K. Thakkar, former Judge, Supreme Court of India, Mr. KTS Tulsi, Senior Advocate and Member of Parliament Rajya Sabha, and Mr. Vikas Pahwa, Senior Advocate, Supreme Court of India, delivered sessions respectively. We would be witnessing session number 4 as part of the knowledge series on law and justice today. The title of the session is Freedom of Contract and Fundamental Fairness, Doctrine of Good Faith, to be delivered by Mr. R. Venkataramani, Senior Advocate, Supreme Court of India and former member, Law Commission of India. Mr. Venkataramani has completed over 40 years of practice in Supreme Court, which had commenced under the tutelage of Padma Bhushan, late Mr. P.P. Rao. In these 40 years, he has witnessed and been part of an extremely important evolutionary period of the court and its jurisprudence. A generalist expert, as are advocates of his generation, Mr. Venkataramani's experience spans over a number of areas of constitutional, commercial, civil, criminal, economic, and regulatory laws. However, his interest in constitutional law began with his association with Padma Shri, late Dr. N.R. Madhava Menon. In his practice in the Supreme Court, Mr. Venkataramani has represented clients ranging from the humblest migrant worker and slum dweller to large private and public sector corporations, union and state governments in civil and tax matters, public and private universities, servicemen and universities, etc. Mr. Menon was his teacher at Pondicherry Government Law College and was the reason Mr. Venkataramani came to Delhi. Through this close association, Mr. Venkataramani has been a part of Dr. Menon's vision of reshaping of legal education in India, including being guest faculty on constitutional law in the early years of NLS IU Bangalore, and his projects relating to access to justice, continuing legal education, and judicial reform. Mr. Venkataramani has served 2 consecutive terms as member of the Law Commission of India from 2013 till 2016, where he worked on key reports spanning issues relating to arbitration law and honor killings. Relevant to today's topic, he also was part of the report on the calculating the strength of judges required for subordinate courts arising from directions issued by the Supreme Court case of Imtiaz Ahmed versus State of UP. Mr. Venkataramani has been a member of various other commissions and expert groups such as Justice M.N. Venkatachalaya Commission, member of the Subcommittee on Directive Principles of State Policy and on Effectuation of Fundamental Duties of Citizens, the Equal Opportunities Commission, expert group on welfare legislation set up by the Planning Commission of India in the year 1990, South Asian Task Force on Judicial consisting of members of SAARC nation to submit reports on the conditions of judiciary reforms in institutional structure. Mr. Venkataramani has also authored the following books: Judgments of Justice, late O. Chinnappa Reddy, a humanist, 1990, Osbury Laws of India, Torts, and the Supreme Court Practice and Procedure, 2019, and has played a significant authorship role in the Indian Restatement of Laws on Public Interest Litigation, a project of the Supreme Court and Indian Law Institute. He has also authored various chapters, articles, and delivered lectures on constitutional law and other subjects. Mr. Venkataramani was recently conferred the Justice V.R. Krishna Iyer National Award by the Capital Foundation, which was presented to him by His Excellency Dr. Pranab Mukherjee, former President of India. Justice late Krishna Iyer is also someone Mr. Venkataramani had the opportunity to work in close quarters with. Without much ado, I would request Mr. Kumar Mihir, who would be the moderator for today's session to set the rules of the House known to the participants, please. Over to you, Mr. Kumar Mihir.
Thank you, sir, and good afternoon to everyone. Before we start with and invite Sir to deliver his lecture, I may set the housekeeping rules. Sir, so all the participants who want to ask questions to Sir can pose their questions in the Q&A box, which is shown on your screen. At the end of the session, we will allow participants to pose live questions to Sir as well. For that, you can use the raise hand icon, which is also available on your screens. Sir has graciously allowed us to ask questions even during the lecture. So whatever interesting questions we may get, I will try and pose that question to Sir. So without further ado, I'll invite Mr. R. Venkataramani, Sir, to start with today's lecture. Sir.
Good morning, everyone, and thank you, Mihir and Kamal, my wonderful team who is organizing this knowledge series, and the Symbiosis Law School for being part of sharing our insights, knowledge, experience for an audience whom we cannot physically meet and talk to, interact. And thank you for this nice Sunday morning interaction. You mentioned about housekeeping rules. I think let's begin on a slightly lighter, tone and then get into the dense thickets of the subject. I think contracts have also a lot of housekeeping rules. And these rules are otherwise called principles of formation of contract and execution of contract. Housekeeping is a very nice word which can be probably extended, given an extended meaning in the context of the subject we are discussing. I'll come back to it in the course of the talk and see why the principles of good faith, fair dealing, and all those which are either seen as a good housekeeping rules or things which are beyond the housekeeping of a contract. So I thank you for this very nice, expression given to me for expanding on the subject for the day. Now, on a subject like this, it's when you, Mihir was talking to me, so we probably would like to look at the Indian experience, the Indian law. It occurred to me that no part of any law in any country stands in isolation today. So much of legal transplantation has taken place. And Alan Watts, who talked about the dangers of legal transplantation, and others have been writing about it. I think when Tugna was writing about it, says that when you transplant, what is transplanted itself undergoes a change. It no longer retains its original character or a feature. Also, as students of law, we have been told that civil law and then the common law jurisdictions and their principles vary in many respects. They are distinct and so on and so forth. But I think in contemporary times, many of the distinctions are melting. Or even if they are distinct at the front, at the core, at the frontiers, they are no longer distinct. So the lines have become blurred. The elements of transplantation, borrowing, then accommodation, assimilating, all that takes place, but owing to what one may call the anthropology dimensions of lawmaking in every civilization and a country. So an anthropologist studies a culture from an internal point of view. How somebody looks, you look at, let's say, a tree in a particular way, a stone in a particular way. I look at it differently. I may look at it very reverentially. So anthropology studies all this. Therefore, if you look at the anthropology of lawmaking in contemporary times, all these very interesting dimensions are, will not escape your notice. Having said that, made very broad observation. I just thought we'll talk about what Adam Smith said in his Wealth of Nations. A very oft-quoted passage, but it makes a lot of sense in the context of our subject for the day. In his second chapter, I just quote it. He says, "It is not from the benevolence of the butcher, the brewer, or the baker that we expect our dinner, but from their regard to their own interest." from their regard to their own interest. He goes on to explain how each of these, pursuing their own business with an eye solely on their own advantage, produces by what is called the Adam Smith's invisible hand, produces by means of an invisible hand an addition to the public good. So for Adam Smith, there are two dimensions of a private interest in production of wealth. So the invisible hand produces the public good, but the outer frame of everybody's involvement in their own self-interest works to their self-interest. So if you look at theories of contract from this perspective, so we can go back to any, Athiya presents a very good historical account. P.S. Athiya is one of the well-known authors on contract law. And he gives a very good historical account, Professor Goddard, etc. You can have any number of names. But before I go into again the details of the subject, some more broad features of how possible approaches the subject in current times would give us a certain understanding of why we need to keep on talking about certain fundamental principles. If we look at 200 years of American history on contract law, there is a good deal of talking about good faith and fair dealing. Judgments have spoken about it. The US Constitution says your contracts impairment clause has a lot of historical potential. And we have borrowed it occasionally in our constitutional history. But if you just briefly glimpse at what Professor Main has been talking about, he says from status to contract is the progress of civilization and the progress of law. But if you compare it with what ancient India and some of the ancient civilizations are talking about, so for Main, a contract means an obligation. It's a pact plus an obligation. But if you look at the concept of dharma in our own country, it is a bond or an obligation, which is a duty, synonym of a right or good. So the right or good, which is so synonymous with a duty or a bond, has a different dimension altogether. So in dharma, an obligation does not bind the parties because of necessity or convenience, but because of the right or a duty. So the old distinction between a necessity or a convenience, therefore you can commit a breach of a contract, or you feel yourselves not bound by the terms of a contract, is an entirely conceptual, jurisprudential framework. Then from a framework where you think it is binding because it is right or wrong not to do or to do. So these are important, fundamental principles which have informed different, jurisprudence at different points of time. Just to catch on to this broad philosophical jurisprudential aspects, I was reading a book written by one Professor Jeffrey Hodgson. There he quotes something like this. Oliver Williamson was a Nobel Prize economist. So in his work on business firms, Oliver Williamson underlined the economic man as a self-interest seeking with guile. Economic man is much more subtle and a devious creature than the usual self-interest seeking assumption reveals. He holds opportunisms as a foundation, assumption of transaction and transaction cost economics. I quote. So this, I think, is a long-standing belief among many economists that business is an amoral arena of self-interest. So Williamson treats culture and ethical values as external constraints on business transactions rather than intrinsic parts of economic activity. That's why I talked about dharma, where right and wrong. So nothing, if ethical values are not intrinsic parts of economic activity, then we start talking about bringing it from an indirect way, good faith, fair dealing, reasonableness. We try to bring it from an external point of view and try to fuse them, merge them, and try to find out how they can still influence the working of a contract, the making of a contract. Now, Hodgson says a basic and omnipresent feature of human relationship is conversation. We had oral conversations, now we have written conversations. Now there is no contract which is not written on a piece of paper or on the net. Now there are interesting cases where some American courts have said in the context of adhesion contracts, they are not binding merely because somebody has done a click wrap or a browse wrap contract. I'll come to them a little later. So it has been argued by Hodgson that important ethical values, including truth, sincerity, and normative appropriateness, are implicit in our dialogue, in our daily dialogue. Therefore, one can define communicative action as a type of action aimed at reaching an understanding. And then, according to this definition, all contractual negotiations in business and trade are essentially communicative acts. Consequently, one may say there is an unavoidable ethical dimension in the negotiation of all contracts, including product making and management, service and labor markets. After all, a contract involves mutual recognition of rights. It also involves agreed obligations and invokes general principles, whether tacit or explicit, concerning different eventualities, including non-compliance, breach, force majeure, so on and so forth. Given the complexities and uncertainties, we say some degree of trust is certainly unavoidable. Therefore, commercial rules invoking basic moral principles are very long pedigree. Then, for instance, giving us a lighter example, everyone who has bought a second-hand car knows that dishonesty and withholding of crucial information are commonplaces. Surveys show that deception is widespread in contracts and markets. But that's not the point to be made here. When you're talking of good faith and fair dealing, we will have some very interesting case law looking into it. Let me look at how in different authors, writers have looked at the good faith dimension and the fair dealing dimension. So somebody writing in 2016 says about good faith and fair dealing. This is what he says in the introductory part of the article. Quote, he says, most contract litigation requires courts to give meaning to contracts using doctrines of interpretation and implied terms. The most ambitious of the doctrines is the implied covenant of good faith and fair dealing. According to the restatement of contracts, in US, every contract imposes upon each party a duty of good faith and fair dealing in its performance and its enforcement. And the duty of good faith and fair dealing is well established in most American jurisdictions. Though few doubt its significance, the duty's meaning is notoriously unclear. That's where the article begins. It says good faith is an intangible and abstract quality with no technical meaning. A different author titles his article like this: the overlap between interpretation and gap filling to achieve minimum decencies. Again, he talks about good faith and fair dealing. A third writer says, the title is very interesting. The implied covenant of good faith in a contract interpretation and gap filling, reviling a revered relic. So some people look at the relic. I'll come into the little details of it. I just thought how people have been looking at the whole issue of contracts and fair dealing, even in their understanding and their perception. Another writer puts it like this. Classical contract theory rests upon three fundamental propositions. First, the exercise of freedom of contract between equal parties in markets of perfect competition is a key to individual welfare and common good. Freedom of contract is defined as the power to decide whether to contract and to establish the terms of the bargain. We have been proud of our freedom of contract, confident that the maximum of social progress will result from the encouragement of each man's initiative and ambition by giving him the right to use his economic power to the full. Second, enforcement of bargains as made protects the reasonable expectations of the parties and promises that we perform and contributes to certainty and stability in the marketplace. All this, he says, on a framework that good faith and fair dealing will inform and be the foundations of this whole framework. I say contracts and obligations are essentially driven by purposes and ends beneficial to each party. It's apparent that the interest sought to be accomplished by each party to a transaction ultimately determines the contractual terms. That's why aspects of offer and acceptance, consent and informed basis, without coercion, undue influence, etc., come in. The importance of the formation of a contract and the freedom involved for both parties to determine the procedures for transaction, as well as the condition of transactions, are important. With reference to consent in case of certain classes of contracts like employment contracts or adhesion contracts, in contemporary times in the digital world, what are known as click wrap or browse wrap contracts, all these are very important. The question that will arise in all these circumstances will be whether, for instance, taking an online or adhesion contract, the online adhesion contract should be binding, even without any express manifestations of the consumer assent to the terms. Two illustrations may be relevant. In case of one Spect versus Netscape Communication Corporation, the New York Court of Appeals held as follows. I quote, Netscape argues that the mere act of downloading indicates assent. However, downloading is to obtain a product, not to assent an agreement. In contrast, clicking on an icon stating I assent has no meaning or purpose other than to indicate such assent. Netscape's failure to require users of smart download to indicate assent to its license as a precondition to downloading and using its software is fatal to its argument that a contract has been formed. The court summary court says it's a good faith dimension. Then, in Ticketmaster Corporation versus Tickets.com, the California court held that the website terms purporting to be agreements could not be considered binding, since it cannot be said that merely putting the terms and conditions in this fashion necessarily creates a contract with anyone using the website. Why I want to bring these two contemporary illustrations to show that we moved from oral world to a written world and to a digital world. Some issues keep constantly recurring. I think they are part of human nature, human transactions. And the way why we fail, why we perform a contract in a particular way, why we breach contracts for reasons within our control and reasons beyond our control. These are recurring dimensions. Then just if you look at what's happened both in France, Europe, and the common civil law world, let's quickly catch up. What do they say? The questions of reasonableness and good faith is being read into contracts has received different approaches in different jurisdictions. The French Civil Code relating to contract implementation includes good faith provisions. The European Court of Justice has referred to good faith as the principle of civil law. And then in 2011 Common European Sales Law proposal included a definition of good faith and fair dealing as a standard of conduct informed by honesty, openness, and consideration for the interests of the contracting party. The interests of the other party, you must keep it in mind, right? Then, and in a 2009 judgment, this is what it says. And it's also said that the concept of bona fide, probably like good faith, is traceable to Roman law, where equity in commercial dealings was required to a very high degree. It is also said the statement was subject to the context that contracting parties were also free to take advantage of each other. That's a peculiar mix of the Roman law. In a 2005 appeal case, R versus Immigration Officer, when Scottish Judge Lord Hope said that the good faith functioned at the level of a remedy rather than right, and not therefore a source of obligation itself. We'll currently see how English courts have been grappling with this difference between a substantive dimension of good faith and the remedial dimension of good faith. And like I was talking about the French Civil Code, Article 1134 of the French Code Civil states that agreement must be performed in good faith. You will find the same principle in the European, common law directives. One, you find Article 1.201 of PECL and Article 1.7 of the UNIDROIT, that these are all treated as rules, and some authors describe these are inserting into positive law moral rules. For instance, going back to France, good faith has been perceived as having twin elements. One, the duty of loyalty and the duty of cooperation. And French jurisprudence has gone ahead in imposing a duty to inform and a duty to collaborate. Good faith in some civil systems has also been extended to the pre-contractual duty, in that negotiations broken off in bad faith may also give rise to liability. Then section 242 of the German Civil Code provides that the contracts must be performed in consonance with good faith and fair dealing. Article 1337 of the Italian Civil Code refers to good faith and fair dealings in negotiation and as well as the performance. Then section 1-203 of the US Uniform Commercial Code also recognizes good faith and fair dealing. It is said that the European Commission treats good faith to mean honesty and fairness in mind, which are subjective concepts, and fair dealings to mean observance of fairness in fact, which is an objective fact. As an illustration of fair dealing, the Commission cites a case, the following case. There is a case of 1-year distribution contract, renewed each year for 40 years, and then terminated by one party by giving 1 month's notice as stipulated by the contract. Given the length of the relationship between the parties, such short notice, even though in accordance with the contract, the European Commission says may violate principles of fair dealing. So the English court has also dealt with some such cases where the substantive term of a contract may not be defeated by, say, the unreasonableness or the lack of reasonableness of a performance of a contract. So the idea of a general doctrine of good faith in the sense of an overriding and objective requirement of fair dealing was not part, certainly, of the English contract law. Courts often go to, I think, Thomas Bingham in an Interphoto Picture Library versus Stelato Visual Program Limited. I'll give the citations later. And then this is what he says. In many civil law systems, and perhaps in most legal systems outside the common law world, the law of obligation recognizes and enforces an overriding principle that in making and carrying out contracts, parties should act in good faith. This does not simply mean that they should not deceive each other. Its effect is perhaps most aptly conveyed by such metaphorical colloquialisms as playing fair, coming clean, or putting one's cards face upwards on the table. It's in essence the principle of fair and open dealing. And says English law has characteristically committed itself to no such overriding principles, but has developed piecemeal solutions in response to demonstrated problems of unfairness. Before we consider certain arguments, recurring arguments, against the adoption of a general principle of good faith, I would probably look at some theoretical foundations. The classical approach to a contract was mainly a transaction involving a subjective meeting of minds of two atomistic individuals competing only for economic self-interest, the Adam Smith's illustration. This reminds us of the famous invisible so-and-so. The traditional freedom of contract theories resists also regulation, and privity of contract must necessarily omit any external fairness principle. As against this, there's something called a relational contract theory, brought more famously into sociology by the French thinker Emile Durkheim. Durkheim states, and he says the relational contract theory proposed by him stems from the principle that contract is a symbol of exchange and society is the basis of the correct contract law. So shift is from individual to the social framework. And then for what purposes? To increase social solidarity by encouraging social cooperation and interdependence of social actors. I think several neoliberal thinkers also recognize that contractual exchanges combine both competitive and cooperative elements. Durkheim would therefore suggest a positive freedom of contract to exist alongside a social and legal standing of fairness. Let's look at some of the traditional elements of contract making. We have facts like mistake, misrepresentation, duty of disclosure, duress, unconscionability, fraud, etc., which can either vitiate a contract, render it voidable. But these are all matters which can be tested objectively. They are not based on any subjective, recognition of fairness and good faith. And it's been argued that, and it will be continued to be argued, that the presence of such vitiating factors will always nullify consent. Therefore, even within the essential elements for making a valid contract, good faith and fairness, in a sense, can be said to be present insofar as the meeting of the minds must be effective and with full disclosure. So this is distinct from good faith and fair dealings in the process of execution of a contract. So you will find the European Commission's illustration I gave is about good faith and fair dealings in the process of execution of a contract. A short notice and termination with a short notice of a long-standing relationship. Therefore, honesty, cooperation, acting strictly in terms of the contract are all matters falling within the domain of execution, distinct from the stage of a making of the contract. In one English case, a Director General of Fair Trading, the English court observed that fairness should be examined when it causes significant imbalances in parties' rights and obligations to the detriment of the consumer and in breach in good faith. For instance, in England, we have the Unfair Contract Terms Act 1977. We have the Consumer Protection Act 1987. These are legislations confined to consumer interest. But otherwise, if you look at their broader social relevance, I think the elements of advancement of good faith and fair dealing in the emerging world of complex trade and commerce is very evident. So you will have a large number of legislation from the mid-19th century and even in contemporary times, you will look at Essential Commodities Act. So in emergency times, how do you deal with trade and commerce? So you may say, therefore, for the purpose of ensuring public interest, consumer interest, so on and so forth, there can be regulatory regimes which will probably delve deep into the question of the freedom of contract. I'll give you just two illustrations, one from England and France, to exemplify these issues.
So the question has come.
Yeah.
Would you say the Competition Act would also
exactly? I'm going to talk about it. Yes, Competition Act, like its precursor MRTP Act, is also, in a manner of speaking, a regulatory aspect of fair dealing of the freedom of contract. So we'll probably ultimately when we talk about where does freedom of contract lie, what are its dimensions, and then what kind of limitations in the context of the Indian Constitution, we'll certainly look at some of these issues. Okay.
Right.
So I was trying to talk about two contrasting illustrations about good faith and fair dealing. One first is the case from England. In Ruxley, a homeowner mandated a construction company to build a swimming pool in his garden. The water depth did not comply with what was agreed upon in the contract by 22 centimeters. The homeowner asked the construction company to rebuild the swimming pool. The House of Lords did not grant the homeowner specific performance. The House of Lords said the swimming pool was usable, although not envisaged in the envisaged way. Therefore, pecuniary damages were sufficient to compensate the homeowner. Implicit House of Lords decision is the idea that it does not make sense to destroy a usable swimming pool to just satisfy the original contract and to satisfy what? Good faith and fair dealing. The combination of pragmatic and utilitarian considerations has been seen as the English model by several authors. Now in France, something else happened. A home was built 33 centimeters lower than what was agreed upon in the contract. In contrast to the House of Lords in the earlier case, the French Cour de Session held that the construction company must rebuild the house because it did not deliver exactly what was agreed to between the parties. Moreover, the construction had to bear the full cost of reconstruction, and the pecuniary damages did not suffice to compensate the homeowner for the broken promise. The reason behind the agreement prevailed over any other consideration one might have invoked. This model has been said to be a model based on good faith, cooperation, loyalty, etc., as we saw earlier in the French Civil Code. These are very good illustrations to show how, regardless of the fact that Europe, with its source of several contrasting theories and approaches to contract law, those contrasts continue to pervade the approaches to resolution of this kind of disputes. And observation made in the context in 2001 by Lotstein, though not directly to good faith and fair dealing, but in context of the current developments in technology and science, etc. He's talking about an old 1909 gramophone case, and he says that case was decided in the heyday of a judicial philosophy of market individualism. But that in modern law, there has been a fundamental change in legal culture, namely towards, for instance, the welfare of employees, towards the welfare of consumers, towards the welfare of social necessities, towards the welfare, for instance, the importance of environment, and so on and so forth. So
Sir,
the ideologies of, yes, any
sir,
questions?
Let me interrupt. Yes, sir. One of our professors, Dr. Garima Yadav, asks a question, and I'll read the question. She said,
Please.
Marx and his followers have stated how laws are created to suit the interest of bourgeois. Sir, do you think that contract laws are framed in a manner that laws, even in good faith, benefits the ruling class or the bourgeois?
You know what Marx said, that the law is just a epiphenomena of the capitalist class, and it doesn't really reflect the interest of society as a whole. And if you certainly subscribe to that, the whole jurisprudence, whether it is Hart, the positivist school, right? Pick up any one of those schools of jurisprudence in 19th and 20th century. They were all talking about the law in the sense of law in relation to social realities, emerging from early 17th, 18th, 19th centuries. And therefore, one can certainly say, in a manner of speaking, the law relating to contract, whether the legislative framework or the principle laid down by courts, they were all probably intended to ensure that market individualism, free market, cooperation within the market, the Adams principle of each one advancing their own interests, and all that certainly can be stated to be correct. But you can't say that somebody took a pen and paper deliberately and said, I will write a contract law to exclude all other interests. Because if contract as a performance mechanism of a particular economic model or an economic framework, then it must necessarily fulfill that role. And if you go back pre-capitalist days, can you say contract did not exist in these ways? So the contract as a transaction mechanism or a form or a method for people to transact their own dealings in their own best interest has always been there. So Chandragupta's days we had it. So in ancient India we had it. You go to China, Confucius will be probably talking about it as a fair dealing. But that is different from the concepts of fair dealing and good faith in the 18th and 19th centuries in the context of market individualism, capitalism, and the emergence of capitalism. There, if somebody is talking about good faith and fair dealing, more spoken about in US than in England. Because you see the importance of an open society, a free market in US was far more different from what happened in England. With a little difference, of course, even though Marx once said about what Britain, the last bourgeoisie in Britain, unless he's alive there, Britain will continue to be a free market economy. So all that's been said about Britain. So we probably keep these distinctions in mind. Let me proceed further, if that answers the question. If there is still more some lurking doubt, I'll come back to it at the end of the day.
Please proceed.
Right. What I want to say is that the leading doctrines of English law, which you just quickly noticed, whether in legislation, in case law, reflect two fundamental ideologies. One, as I said, a market individualism and a consumer welfareism now. Putting the contrast very generally, I'll put it like this. Whereas the market individualism ideology insists upon contracts being held to their freely agreed exchanges, the latter seeks to ensure a fair deal to contractors and more generally to relieve them against harsh or unconscionable bargains. Today, when you talk of a contractor in highly evolved technological societies, it is not really those big industrial and trading corporations which are in contracts. All of us are involved in contracts. Whether I purchase a toothbrush or a toothpaste or a piece of paper, take any one of these, we're all involved in contracts. Therefore, where a person is involved in a contract merely as a consumer, the interest will be very different from a person who is involved in a contract as a producer, a service provider. And also, for instance, we have a very complex technology-driven contracts in contemporary times. So we're not talking about them alone. We must talk about everybody involved. Therefore, in a manner of speaking, contemporary society is essentially a contract-driven society. Today, we can neither wake up nor go to sleep without entering into a contract. So from cradle to grave, we are into a contract-driven society, but different people enter into contracts for different reasons. In a manner of speaking, I would also say, if you have an open society, you believe in an open society, a transparent society, where knowledge acquisition is important, or knowledge sharing is important, and both these dimensions come very, very closely into a contract-driven society. So I think I'll move on to a few more aspects of this market individualism and the consumer welfareism, and then proceed to some case law.
Sorry, sir, if I can interrupt. The question has come from Dr. Meenakshi Kaul. She wants to know the position of contract in Eastern jurisprudence, because you mentioned Chandragupta, and its compatibility with present system. So would you like to throw a little light on this?
See, there are a lot of good deal of writings on our ancient, Hindu law. I think I remember there was one article translated into Sanskrit by Chandra Ghosh or Professor Jolly on ancient Hindu law, looking at the principles relating to contract making, principle relating to compensation, damages, breach of contract, frustration, so on and so forth. So you will find, if you pick up Justice Ramajoy's book on Hindu jurisprudence, you will find there are separate chapters about dealing with all this. And then we had this treatise which dealt with what called aphorism called Atara Kachari, 18 treatises, as they call it. The Karnataka High Court, in fact, is also said to be built on somewhere, as Ramajoy used to tell me, there are some 18 principles of Hindu law where the basis for the initial thinking on how a building should be built. Very interesting. Anyway, so you will find, I think this treatise called Raja Tarangani talks about, the principles of governance and also how a king would respect contracts between citizens. There are a good deal of writings on that. But then we need not go back to our smritis and smritis and to find out whether a contract was always there or not. As I said, I think no society, the moment we entered into an agricultural sedentary framework, I think contract became a part of life. So exchange and barter became part of our life. So whenever exchange and barter became part of human life, essentially some rules would have evolved. There can't be that merely somebody said, let there be dharma, and therefore a contract resolution was resolved. It was not like that. So there are principles of compensation, damages, and then quantum of damages. Manu somewhere deals with them, and of course to our dissatisfaction, not to our acceptance. So let me go further. Any question now on this? No.
No, sir.
Okay. All adjudications, whether in England or France or US, or you take up any one of those cases, countries, they're all caught up in what I may call in a tension between the ideology of formalism, which dictates that settled law should be applied, precedent should be followed, and so on, and the ideology of realism, which demands what? Which demands that cases should be determined according to their merits, settled law notwithstanding. All of us know that common law is all about this tension and how common law grows and contributes to the interstices of the law. In practice, this double layering of ideological tensions generates three strands in judicial reasoning, which we'll see in some other cases. One, a formalist regard for applying the law. Secondly, a market individualist brand of realisms with the emphasis on calculability and holding contractors to their bargains. That's why very often courts reluctant to say, I will not imply a term of a contract. Right? And third, a consumer welfareist brand of realism concerned with protecting contractors, particularly consumer contractors, against sharp practice and generally relieving against unconscionable deals. Somebody says this is a dynamic market individualism responds to these difficulties by doing what? By favoring a more flexible approach, guided by practices and expectations of the contracting community. If the commercial community favors protection in certain situations for pre-contractual reliance, enforcement of agreed variation, even though they may be one-sided, recognition of third-party interests and the like, then dynamic market individualism argues that law should run with a grain of opinion. A textbook statement of such opinions can be found in Lord Wilberforce's well-known remarks in this, where he says, the whole of contract is of a commercial character involving service on one side, rates of payment on the other, and qualifying stipulations as to both. The relations of all parties to each other are commercial relations entered into for business reasons of ultimate profit. To describe one set of promises in this context, gratuitous or nudum pactum, seems paradoxical and is prima facie implausible. It's only the precise analysis of the complex of relations into the classical offer and acceptance with identifiable consideration that seems present difficulty. But this same difficulty exists in many situations of daily life. And what are they? Example, a sales at auction, supermarket purchases, boarding an omnibus, purchasing a train ticket, tenders for supply of goods, offer of rewards, acceptance of by post, then warranties of authority by agents, then manufacturers' guarantees, and then gratuitous bailments, then bankers' commercial credits. I think the list is endless. So that's why I said we are in a contract society. These are all examples, as Lord Wilberforce says, doctrine of examples of how English law, having commanded itself to a rather technical and schematic doctrine of contract, in application, it takes a practical approach, often at the cost of forcing the facts to fit uneasily into the marked slots of offer, acceptance, and consideration. Alan Fons is a well-known writer on contract. He says that on the Uniform Commercial Code in US, that the criterion of good faith should be constituted by reasonable commercial standards of fair dealing in trade. In an Australian case, this is what a learned judge said. I quote, people generally, including judges and other lawyers from all strands of the community, have grown used to the courts applying standards of fairness to contract, which are only consistent with the existence in all contracts of a duty upon the parties of good faith and fair dealing in its performance. In view, in these days, they expect a standard, and anything less is contrary to prevailing expectations. Emphasis prevailing expectations. In other words, there is a general expectation that contractors should deal fairly and act in good faith, which crystallizes into what? Into more specific views about how far self-interested opportunities, shrinking, manipulation, and the likes should be restricted. Now, coming to the Indian context, we are no longer in the pure domain of the Contract Act. The Indian Contract Act, modified model and English law, has not obviously enacted the general principles of good faith and fair dealing as necessary elements of contracts. We have, for instance, sections 166, 178, 178A, and 223, which uses the expression good faith. They're all expressions used in the context of a principal and an agent. I'll presently deal with some of them. So contracts are treated as void or voidable for other reasons. Mere lack of good faith or fair dealings is the process of entering into a contract will not by itself vitiate a contract. However, one can certainly confidently say matters such as misrepresentation, deceit, fraud, etc., which have entered into the making of a contract. And obviously the contract will fail. But what is there the difference between honesty and fairness in the sharing of facts and information necessary for conclusion of a contract and the good faith and fair dealings in the execution of a contract? Do we see any difference between them? As we saw about the European and the civil law position, good faith and fair dealings are integral to the execution of a contract, closely in tune with the terms of the contract, or matters which are post-contract forming stage. The Constitution of India obviously guarantees the right to freedom of trade and commerce. Contractual transaction inform trade and commerce and is a pervasive method for human transaction. And it involves exchanges of property value, intellectual properties, and all other forms of property in contemporary times. This freedom, as we all know, is subject to certain restrictions, and then which the state can impose within the scope of such restrictions. Contracting parties are absolutely free to act in advancement of their respective interests. The question as to beyond mistake, misrepresentation, etc., what form and content, good faith and fair dealings can still take and become part of a contract, Indian contract law, cannot be answered in the abstract. The law relating to contracts entered into by governments is fairly well settled. One broad guiding principle is that regardless of formalities and procedures, the state must act fairly, reasonably, in public interest, without nepotism or favoritism, avoid unjust enrichment, be subject to principle of estoppels, etc. Some illustrations in the regard will serve the point. I'll just pick up one case where how in the source of a contract making power and implied good faith and fair dealing, even though the Supreme Court has not specifically dealt with that. We have that Indian aluminium case of the Kerala State Electricity Board in 1976. There, the Electricity Board entered into a contract with a consumer and promised for a particular period of time that you will have the tariff in the following terms. Now, a little later, in exercise of the same statutory power of making a tariff, the board fixed certain general principles of tariff and said, now, my contract entered with you no longer binds me. The Kerala High Court said, the contract will not fetter the exercise of a statutory power of the board. So no contract can fetter a statutory power forever in future. The Supreme Court took a different view. It's one thing to say that if you exercise a general statutory power to do a certain thing, nobody, a statutory authority will not fetter themselves their future statutory exercise of power. But if you enter into a transaction by invoking a particular provision of a law, and that provision enables you to enter into a contract, and the same provision enables you to also enter into a policy transaction, the court says there is no conflict between these two transactions or events. Both emanate from the same source of power. Therefore, there is no question of a fettering of a future power. Once you have entered into a contract, this contract binds you. The Supreme Court has not gone into good faith and fair dealings, etc., as a dimension to protect their contractual interest. But the underlying principle is, even if you have to exercise a statutory power, when can you go back on the exercise of a statutory power? So all those principles we saw in the context of state action and state contracts can certainly be profitably invoked. But much more fundamentally is what we are talking about is, if a contract is formed even in the exercise of a statutory power, and good faith and fair dealing must necessarily continuously inform the expectation, the reasonable expectation, the general expectations we're talking about, the Australian case I cited. So I think that will be an important dimension to be added wherever possible. Probably the courts can be told that the good faith and fair dealing is ultimately what? That if you exercise your power in invocation of a particular authority, you will never go back unless there is a larger public interest. And that larger public interest must also be a matter of good faith and fair dealing. So not because it's a subjectively seen a policy decision or a shift, etc. Now, that's a good illustration. Lots of other cases have dealt with that. For instance, we have some cases relating to sections 68, 69, and 70 of the Contract Act. That famous Mandal case where even if a contract is not entered into, strictly in terms of Article 299, the case law in Article 299 of the Constitution is that a contract which doesn't fit into the 299 model is no valid contract at all. It doesn't bind the government, and then there is no estoppel against it, and so on and so forth. But even in those cases, the court has invoked Section 70 and etc., saying that you are entitled to compensation and damages. What is the basic principle? Not merely because the contract law states so, but because I think essentially good faith and fair dealing must come in to inform all state action. So today, therefore, one extension of this principle, I'll give those citations a little later. One extension of this principle is that, as we say that today we live in a contract society, we also live in, let's say, an open society. We also live in a society where markets must flourish. We also live in a society where individual freedom, innovation, creativity must be regarded and promoted. But we also live in a society where equality must be promoted. So we also live in a society where Constitution promises several values and several guarantees. And many of these guarantees touch upon what an egalitarian social order. So how do we really ensure that these seemingly apparent, conflicting values do not really conflict? And wherever there are conflicts, because we are talking about constitutional law in the abstract. We are talking about how, in the context of contracts, whether by a legislative power or by exercise of a statutory power or exercise of executive power, whether the state will ensure that the harsh edges of a contract law, the making of a contract, the performance of a contract, consequences flowing from a breach of a contract, all this, the state must ensure that the harsh edges must not be harsh enough. So that's where I think we can probably build a jurisprudence of good faith and fair dealing as a fundamental informing principles. Even if you ask me the question about the competition law. I mean, why do we need a competition law at all? Is it solely oriented towards the consumer interest, or it is also or it's focused at how to fine tune and lubricate the economics of competition, or the competition in economics, whichever you put at it. I think both purposes are involved in it. The whole lot of history on the Sherman Act, the antitrust law in US gives us a lot of interesting examples. We also moved away from the MRTP framework to an entirely different understanding of the competition law. And even though some lingering, ideas of the MRTP do come into the competition law, people still talk about it because I think it doesn't leave us so easily. So the competition law is also like the consumer law, an example how legislature can intervene and say, this is how in contracts, what I call the edges of the making of a contract, the consequences which may have consequences for third parties who are not parties to a contract, so including competition, how do you really deal with them? So one can possibly say, all right, as a good academician, I'll say everything is solved by saying good faith and fair dealing. But I'll just show you some examples from how US courts have grappled with this. I'll read a couple of pages from a very well-written article on this piece. Give me just a few minutes. Yeah. And this is again what this learned author writes in the introduction in his talk about good faith and reasonable expectations. I quote, the recognition that there is an obligation of good faith in every contract has been regarded as one of the most important advances in contract law in 20th century. Nevertheless, a half a century after the Doctrine's incorporation into the restatement of law, they said the many judicial opinions are confusing or confused. The controversy and confusion stem from a fundamental misunderstanding about the nature of good faith obligation. That misunderstanding is a belief that good faith is a special doctrine that does not easily fit within the structure of contract law. Indeed, the doctrine is seen as a potentially dangerous, threatening to undermine more fundamental doctrines and the transactions that are designed to uphold. As a result, good faith must be substantially restricted in its application. In particular, the doctrine needs to be closely tied to the terms of the contract, limited to the cases in which a party has willfully violated its obligations under the contract or both. Says all of this is wrong. There is nothing special about the doctrine of good faith. It is continuous with the rest of contract doctrine. Although it is distinct from other doctrine, it is only distinct in the same way that the rules about formation are distinct from the rules about consideration. Good faith is simply another embodiment of the basic principle of contract law, the protection of reasonable expectations. We all talk about it in the administrative law, legitimate expectations. The application of that principle through the good faith obligation leads to the proper understanding of the content of the doctrine and the rejection of many of the ways that courts improperly cabin it. Then he goes on to quote two other authors. There's an analysis pioneered by Robert Summers. He says this, there is a long-standing and well-defined scholarly debate about good faith, conventionally characterized as the conflict between the excluder analysis, pioneered by Robert Summers, and the foregone opportunities approach described by Stephen Burton. In a pair of landmark articles, Summers first described the doctrine of good faith in a way that is remarkable for an attempt to formulate a rule of law that may have contributed to the continual uneasiness about its status. Summers described a good faith as a phrase which has no general meaning or meaning of its own. He then situated it among a family of general legal doctrines, including implied promise, custom, usage, fraud, negligence, estoppel, and further the most fundamental policy objectives of any legal system, namely justice according to law. Then the restatement of law as adopted Summers' analysis. Then Burton criticized this restatement and formulation for its vagueness and for the reference to standards external to the contract, and he developed an approach that analogized breach of good faith obligation to simple breach of an express term. In both instances, Burton suggested a party attempts to recapture opportunities and commits resources to the choices made. In doing so, it creates expectations in its contracting partners. And then all of us all know about the most well-known American judge, Judge Posner, who is academically so, his first book on economic analysis of law is so well known. And Posner and also says, in a well-known series of Seventh Circuit cases, in their view, good faith is simply a step at approximating the terms the parties would have negotiated had they foreseen the circumstances that have given rise to their dispute, rather than an injection of moral principles into contract, some newfangled bit of welfare state paternalism. Instead, the essential purpose of the obligation of good faith is to achieve efficiencies that the parties as a rational maximizers would have agreed at the time of contracting, such as minimizing the cost of performance by reducing defensive expenditures. This issue is in the first good faith in relation between the express terms of a contract and the obligation of good faith is well noted in a case on Burger King Corporation versus Weaver, decided way back in 1999, in which a franchisee alleged a violation of a good faith by a franchisor. In Burger Court, the court severely limited the scope of good faith by looking only at the express terms as a source of the obligation. And then whether the violation of the good faith obligation requires that the parties subjectively intend to do so, and another connected issue, namely how the standard of good faith is defined and what sources the courts would look to in defining the standard, You look at another case, which is Brunswick Hills Racquet Club, decided in 2005 by a New York Court of Appeals, in which a New Jersey Supreme Court capped a line of lengthy opinions and summarized the law of good faith in 2 paragraphs. And the court said, in that case, a commercial tenant held an option that could only be exercised by giving notice and tendering a payment to the lessor. The tenant gave the requisite notice, but failed to make the payment. I think because of acts of series of written and verbal evasions by the lessor and its lawyer designed to defeat the exercise of the option, which is not in the lessor's economic interest. I think under the New Jersey law, they find that the application of good faith was not limited to a gloss on express terms, as in the earlier Burger King case we thought, but the lessor's demonstrable course of conduct in total disregard of the harm caused to plaintiff constituted a violation of good faith, even though it was in accord with all of its obligations under the express terms. Now, this is what the court said. The Uniform Commercial Code, as codified in New Jersey, defines good faith as honesty in fact and the observance of reasonable commercial standards of fair dealing in that trade. Good faith conduct is conduct that does not violate community standards of decency, fairness, or reasonableness. I mean, somewhere courts have evolved, in English courts have thought about business efficacy. You find it very often repeated in many English decisions. But what is this community standards of decency? How do you define it? The court goes on talking about it. It says community standards of decency, fairness, or reasonableness. Good faith performance or enforcement of a contract emphasizes faithfulness to an agreed common purpose and consistency with the justified expectations of the other party. I think too many things rolled into a common roller coaster. The covenant of good faith and fair dealing calls for parties to the contract to refrain from doing anything which will have the effect of destroying or injuring the right of other party to receive the benefits of the contract. That is very simple, one can understand. So, but then the question of how do you ensure you receive the benefits of a contract? You will have to invoke all these doctrines and principles, add them as a corpus of law, and say, therefore, ultimately, what is good faith? And that's how the court raised. Then, as the author says, this opinion is literally incoherent in the sense that its particular elements do not cohere into a comprehensible whole. There are many cases decided by the courts of appeals and U.S. appellate, federal courts. I don't want to multiply these examples, but just to look at what do we say about express terms and good faith. All of us know that in contract law, the terms of the contract bind the parties. The court will not easily imply terms. In many cases, Supreme Court has said, but business efficacy. In one of the cases, I remember, I think NABA, Punjab State Electricity Board, the Supreme Court said it is a case of transporting coal. You transport coal, store, and then transfer, etc. So NABA said, I must wash the coal before I can store and transport them. And then washing expenses are to be claimed. Question is whether in the express term of a contract, washing coal is not explicitly stated. Can you claim expenditure incurred towards washing coal? The Supreme Court said business efficacy. You don't transport coal without washing it. Therefore, we'll imply it as a part of a term of a contract. So, and then the court does not talk about good faith and fair dealing. The court says we will go by the well-settled principles of English law. Namely, we will imply a term which will add a business efficacy to a contract. But just picking up what the New Jersey court has said. So if expectations of a contract maker is to be fulfilled, and you find too many impediments in fulfilling the expectations by traditional conservative principles of contract law enforcement, then can we, like what has happened in administrative law, English administrative law principles have added on over a period of time, how doctrines after doctrines and principles after principles to ensure that what is ultimately said to be reasonableness and fairness. So it is said in the context of legitimate expectation, the English court said that this is the latest addition, and proportionality, all that. So these are principles which courts evolve to supply what is missing in the law to ensure a proper, efficacious, and just resolution of a dispute. Therefore, when you're talking about the conflict between the express terms and the implication of a term, perhaps to the extent that business efficacy is a well-known principle, we may add on a clause saying that if a good faith and a fair dealing will add a greater quality and meaning and enhance the quality of the performance of a contract, perhaps one can say the implication of a term in a contract will be aided by adding on or falling upon the principles of good faith and fair dealing.
Sir,
any question now? Yeah.
Put few questions.
Yeah.
Yes, Mr. Banerjee, Mr. Shobit Betal, they want similar questions regarding one-sided contracts. For example, in cases of banking contracts or real estate contracts. And Professor Rajneesh Jindal is also asking employment contracts being one-sided. So do you think that it is time for the legislature to intervene and do something about this?
How do we put all these contracts into one basket? That's not possible. There are different purposes, aims, and ends which will be served by these different sets of contracts. Now, in the context of employment contracts, we know when it comes to state employment, we have no difficulty today. Yes. We have a larger number of judgments which have crystallized the principle in relation to fairness in terms of appointment, selection, termination, so on and so forth. So there it doesn't present a problem. But in private employment, still there is a problem. And in section 14 of the specifically Act, contracts of there is an embargo against enforcement of such kind of contracts. We have, I think, long back in 1968, Supreme Court talking about how 14 cannot be invoked to ensure and a contract of a private contract to be specifically enforced. Probably, I think there we need to move on into a more introduction of infusion of more fairer elements. But it comes to certain other situations, like for instance, the journalists, working journalists, or workmen, or quasi-workmen, one may use that kind of a term. The larger number of labor-related legislations where the principles of fair dealing are implied. Unfair labor practice is essentially nothing like the converse of the principle of a fair dealing, isn't it? So, but when you talk about the other kinds of a contracts, commercial transaction like a banking or a real estate, there are still some legislations which try to ensure that some kind of a fair dealing is made available to you, whether it is the RERA Act or any such legislation. But they may fall short of the actual working realities and the needs of the consumers. When you talk of the banking institution, I think we don't really have a consumer angle law, right? If I enter into a banking transaction, I want a loan, and the loan is taken only on the terms stipulated by them. And that's like the adhesion contracts. Even today, we have a larger number of adhesion contracts. That's why I give that example about the click wrap and the browse wrap agreements on the on the digital world. So the digital world, many contracts are simply you click and then you accept. You browse. The very act of browsing can also sometimes be an assent to a contract. So either you take it or leave it, kind of a old principle. So in banking law, there is still this problem. But then the moment you talk about a consumer-oriented, consumer welfare banking law, there will be too many probably a banking industry can say, look here, we'll collapse. Because the whole banking, fundamentals of banking depend upon certain commercial and economic and financial principles. The moment you want to tinker with them. So, but probably one can say, it's one thing to talk about the formation of a contract and the principles and matters will go into the making of a contract, but relaxing or dealing with the rigor or the consequences or the enforcement of a contract. You know that in the real estate, that's what's really happening. So the consequence of enforcement of a harsh, a contract, harsh consequences how do you really enforce them in a way which is more acceptable, more humane, comfortable, fair, so on and so forth? Again, I think courts alone probably will now fill up this area, because I think the moment you come in with a legislation, the problem will be it can become a little rigid. It may not admit of a flexibility in certain in the market conditions. So, but unless we're able to bring in a very flexible legislation providing for both these aspects, namely the formation of a contract will not be dealt with by the law, but to the enforcement of a contract insofar as it ensues certain consequences. So how do we really ensure the consequences are not harsh? One can still look at it. I think it's a good idea, but the principle will be ultimately said, why do you want to look at them? Is the current Contract Act not sufficient to supply all those materials which will be good enough to deal with all the situation? If the answer is no, yes, then we need to look at it beyond the current contract law. But I think the answer is no. The contract law is, after all, a colonial piece of legislation. It was modeled on the same principles of market individualism as the Adam Smith days. And we have gone far, far beyond that. So I think there's a good deal of sense in what these suggestions are talking about. Any other questions related to it?
Yes, sir. Yes, sir. Then other question with respect to employer-employee contract, and because you talked about media, Mr. Satyaprakash has asked a question that contracts in media industries are generally against express provisions of Working Journalists Act 1955. Notwithstanding the protection given by the Act, employees are fired. So what is the remedy available to them? Invoking Industrial Disputes Act or filing writ petitions?
File what?
Filing writ petitions. So what is the remedy available to such working journalists or with people who are party to these contracts in media industry? Should they invoke Industrial Disputes Act or file writ petitions?
I think a combination of both. Probably, see, as we are talking about, I have not referred to many of those English cases. And many of those English cases had two twin elements. One, how do you really terminate a contract? Is there a reasonableness, a principle of reasonable expectation, reasonableness and fairness in termination of a contract? If you want to invoke principles of reasonableness by giving, let's say, a short notice, or by without giving a notice, because the express terms of a contract provided that you did not give a notice or give only a short notice, so on and so forth. Therefore, in the context of a conflict between express terms and the expectations such as reasonableness, the courts have said the two are independent. But we cannot probably imply a reasonableness term in a contract where the express terms expressly say no reasonableness and provide for certain other ways of doing it. So if you go on those terms and look at how termination take place in India, I think those examples will not probably be opposite and relevant. One good reason is we have a constitutional framework. The constitutional framework says even your freedom of trade and expression is subject to reasonable restrictions. The Working Journalists Act is one such restriction on a freedom of trade and commerce. So the Working Journalists Act, insofar as it can be interpreted to mean reasonable expectations and fair dealing and so on and so forth. And where one finds a particular dealing or a termination or any one of those conditions of service being dealt with in an unfair manner, then it says, you can probably say, look here, this is what the law implies. This is what the law perceives and envisages. So I go to the High Court and say, this is contrary to the constitutional reading of a law. You can go to the High Court for that purpose alone and not for any other purpose. And of course, the High Court, some very intelligent judge may say, you are indirectly invoking a private law remedy into a public law remedy. It may happen, but I think we can still do that. The second is, you directly go to the Industrial Disputes Court and say, I am asking for a preliminary statement on the interpretation of the law before you lead evidence and all that, right? And if whether the conciliation agency or the industrial court says, no, I cannot do that, I think you can go to the High Court. both in civil procedure code and the criminal procedure code, if there are issues of constitutional interpretation of a provision, then the court will refer the matter to the High Court. I think Article 228 and
Yes.
also some provisions in CRPC, they say the matter will be referred to the High Court for a declaration or a statement of law. So we can try many of these very innovative procedures and a combination of these procedures, which may probably lead to a change in the legal framework.
Sir, another question, Professor Megha Nagpal has asked.
Mr. Kumar Mihir, can we take a couple of live questions before that?
Sure, sir. So I just wanted to, anyways, well, let's take the live one. I'll come back to this question. Yes.
Samyajit,
Yes.
please unmute yourself and ask a question live. Samyajit.
Good afternoon, sir, and good afternoon, all of you. It's a pleasure to be there in this webinar. And my question is, sir, basically, that what is the scope of this impossibility of a contract in terms of Section 52 of Contract Act?
In what context are you asking this question?
This question basically in a question when there is a contract and there is an inability of the one party to perform it in a way, then the contract is in force.
Yes.
It's in the terms of that actually I want to ask a question. If there is an impossibility to perform a contract, then what can be the reason, though there is no provision in the contract? So,
No, what does Section 56 say? Section 56 only say an agreement to do an impossible act itself is void. So what do you mean by an impossible act? Within the capacity of both the parties, you visualize a certain thing and within your capacity you cannot do it, it's impossible. Right?
Right, sir.
Right. But then you may contract to do certain things which you reasonably expect to be performed. But in the course of performance, your reasonable expectation fails.
Right, sir.
When the reasonable expectation fails, right? Section 56 also talks about both of them.
Sir.
It says a contract to do an act which after the contract is made becomes impossible.
Sir.
Or by reason of some event which the promiser could not prevent.
Sir.
Unlawful or becomes void, then the act becomes impossible or unlawful. So these are post-contractual, contingencies on, events which may render the performance of a contract impossible.
Sir.
So courts have all dealt with what will become impossible after a contract is formed. We also know that this force majeure principle, frustration of contract are so well built into Section 56 case law. And there has been a good deal of discussion in current times after the COVID lockdown that whether the force majeure will be relevant for this current situation and so on and so forth. There's a very live discussion going on that question. So the question is, if somebody enters into a contract which is lawful, valid, capable of being performed within the reach of the performing parties, but later it becomes impossible. It can become impossible because of an intervention of a law. It becomes impossible because the fundamental existence of a contract has disappeared. So it can be any number of reasons why the contract become impossible. But where somebody deliberately, induces the impossibility of performance, that will be a different situation altogether. That will be a case of a breach of a contract, leading to a frustration of a contract by a volitional conduct. And that can always be detected, whether it is impossible because of your conduct or impossible because of external reasons. That's how one has to approach that. And the law provides, Section 50 provides for compensation, damages, so on and so forth. That law is very well settled.
Thank you, sir. We'll move on to the next live question. Dr. Meenakshi Kaul, please unmute yourself and ask your question live.
Am I audible, sir?
Yes.
Yeah. Good afternoon, sir. Firstly, let me thank you because your presence has definitely enriched this session. Now, the question is, as far as good faith and fair dealing is concerned, I feel that it is deliberated upon the integral part of the contract, whether provided in the statute or not. So I need your opinion, sir, on this. do you believe that it has its roots in Pran Jaya par Vachan na Jaya, which is again a concept of Eastern jurisprudence? So I would really request you to elaborate on this.
But why do we see, when we talk of history, sometimes it's fascinating because things which we did not know are so exciting and interesting. The other reasons why also we fall into history because, oh, my country, my jurisprudence is richer than let's say the East and the West issues. All of us know that. But insofar as certain dimensions of any principles of any law and jurisprudence will add on to an enduring value and dimensions of justice, we can certainly pick them up. Not because they were grown in a particular culture or on a civilization, but because they have eternal relevance and value. I remember the title of a book called Laws Which Are Partly Common to All Humankind by an American author. He picked up that phrase from, the international law. We have this phrase called just commons, just cogents. Now, he says, look at Roman law. Rome was the center of ancient trade. We all know about the Silk Route from China to Asia to Rome. And so Rome was the center of ancient trade where people from virtually from all over the globe used to congregate and conduct their trade and commerce. The peculiar problem was then, how do we really do justice if there is a difference of a dispute between somebody coming from China and somebody coming from Africa? Now, Rome evolved a principle. It borrowed, put them all into one basket. It looked at all those principles which are common to all humankind. Principles which are common to all humankind. And another old principle was, if I'm a trader from India, I brought with me my own principles of law, and they must be applied. I carried my law with me. So Rome sought to resolve all these issues by saying, let us look at all those principles common to all humankind, put them together. And that's how you'll find these, when you're debating this kind of issues, probably we should look at from this very larger global perspective. That's why I mentioned about, we are in a very different jurisprudential cauldron, where there is nothing like a colonial hegemony or nothing like a colonial superiority. I would probably say, as an observer of law in 21st century, from a practitioner's point of view, we have now all jurisprudence in one basket, which has to be, I think, redone from a global perspective. I'm not talking about international human rights documents. They stand on a different footing. So we have all the rich corpus of principles of law in relation to contract, in relations to state action, in relations to private, expectations. So you look at what happened in Germany. In German civil code is also the principle of fair dealing. And so you have very interesting examples in many of these countries. Let's put them all together and try to find out if we can weave one common fabric of principles, which will be applicable to divergent legal systems or divergent constitutional systems and divergent legal frameworks. And that's how, today we have another problem. Constitutional courts, when they want to interpret constitutional provisions or even some statutory provisions which are commonly found in various other jurisdictions, Justice Scalia, the US Supreme Court, was very averse to borrowing principles from the rest of the world. And I think he said in one Roberts versus Simmons that, why do we need to look at the jurisprudence of death penalty from the rest of the world? If the US Constitution has not given us enough jurisprudence, no other part of the world can give us jurisprudence on this. So we have those kinds of views. But then we also other kinds of what's called global scholastic, scholarly dimensions. So we are probably looking at that. I'd only say that let us endeavor to evolve what can be useful at a global level.
Thank you, sir. Professor Megha Nagpal wants to know your view on evidentiary sufficiency and standard of proof in case of non-performance of a commercial contract especially in these pandemic times, party invoking force measure, how to judge if it is invoked in good faith?
Evidentiary
sufficiency, sir. What should be the standard to judge that something has been done in a good faith?
No, what do we say when generally forget about the pandemic and all that?
Yes.
So you can't just pick out a fig leaf out of somewhere and say this is how the pandemic situation will be dealt with, right? So what I would say is, in ordinary circumstance, when there is a non-performance of an obligation, what are the principles of evidence? We have all those well-settled principles of evidence, the Indian Evidence Act. And we have primary evidence, secondary evidence, tertiary evidence, hearsay evidence, and as I always try to say, the definition of proof. If you look at the definition of what is proved in the Indian Evidence Act, right? Please pick up the definition of proved, and somebody probably should take up one whole semester on how do you really deal with the definition of proved in the Evidence Act. So, but then in current times, the evidentiary value, how do you lead evidence? What principles of evidence would be more opposite to proving a particular aspect or a fact, or more point, because we live also in a digital world. The question of proving what happened in the digital world has its own special problems and difficulties. So combined with both, so probably we cannot bring in an oral tradition principles of the Evidence Act, which depends on oral evidence, written evidence, documentary evidence, into the digital world. But I think one thing is so fundamental. One, you want to say that, look here, what I did was in good faith. The onus will be on you to prove that, right? So good faith means what? Whatever are the terms of your contract. Insofar as, for instance, we talked about the French, the twin dimensions of the French Civil Code, loyalty and cooperation. Suppose you bring in loyalty and cooperation, and you say, look here, I've been loyal to the express terms of the contract. I have cooperated reasonably to the expectations of the other side, and therefore I say I've acted in good faith. You have discharged your duty of evidence, placing evidence. But I don't think the law will require much more than that. The law will require, therefore, how do you prove good faith? From what perspectives? What elements of good faith would be relevant for a particular contract? So good faith for a particular contract will differ from contract to contract. You have all those huge commercial technology-based contracts, good faith will stand on a different footing. If you simply look at, let's say, an employer-employee contract, good faith will be on a very simplified basis. So the complex dimensions of it being able to prove good faith will depend on the contract concern.
Mr. Abhishek Kaushik has a live question. Mr. Abhishek Kaushik, can you unmute yourself and ask a question? Mr. Abhishek Kaushik?
Yep. Yeah, am I audible?
Yes, please. Go ahead.
One minute. I just want to add on to the last question before I answer this question. There's I made a note of it. It just came to my mind. There's an old case it's a case decided in 1968 by I think the California Court of Appeals, called Pacific Gas and Electric Company, and this is what the court said. The test of admissibility of extrinsic evidence to explain the meaning of a written instrument is not whether it appears to the court to be plain and unambiguous on its face, but whether the offered evidence is relevant to prove a meaning to which the language of the instrument is reasonably susceptible, because limiting the determination of the meaning of a written instrument to its four corners would either deny the relevance of party intentions or presuppose a degree of verbal precision and stability our language has not attained. This importance is because limiting the determination of the meaning of a written instrument to its four corners would either deny the relevance of a party intentions or presuppose a degree of verbal precision and stability our language has not attained. Yeah, what's the next question?
Yes,
Yeah.
Abhishek question.
Hi, my name is Abhishek. Thanks for this lecture, sir. It is always a pleasure, whether hearing you in court or in this webinar. So I want to thank you first before I ask my question. My question, sir, is in relation to section 19, which says
Section
that under consent,
19.
yes,
All right.
it says that under section 19, consent to an agreement caused by fraud or misrepresentation makes the contract voidable. But there is an exception to that when the section says that if such consent was caused by misrepresentation or silence, fraudulent within the meaning of section 17, the contract nevertheless is not voidable if the party whose consent was so caused had a mean of discovering the truth with ordinary diligence. Sir, the question is in context of active silence by the insured. Now, he knows I had to disclose. He chooses not to disclose. Can the insurer or the insured claim this to be protected under section 19 and say that, look here, I had not disclosed to you. It was your duty to find out. If you had exercised due diligence, you would have found out. So therefore, you can't now post an uberema fide obligation on me and say that I'll repudiate it. You had the means of finding out. You did not find out and therefore not liable to hold me liable for repudiatory breach. Thank you.
You know that contracts of insurance are contracts of good faith. Essentially, right?
Yes.
That's right. Now, what does it mean? Does it mean that the insurer has all the responsibility to find out all information from the insured? Is there an engine of knowledge, information knowing by which all information can be known by the
I
insured?
must clarify, I am not asking on the active misrepresentation. I am on concealment.
I'm coming to that.
Yes.
We'll come to that. We'll come to concealment. So the concealment happens. What do you mean by exactly by concealment? What do you talk about silence? That is, in a situation where you are entering into a contract on the basis of good faith, because you are, by merely paying, let's say, an insurance premium, he is assured of a certain larger return at a later point of time. The insurer, right, is entitled to lay down their rules of insurance. They're entitled to lay down their principles as to how the insurance premiums will be calculated, how the insurance will be paid, so on and so forth. All these are based on a certain principle of good faith. Now, suppose you say that, very often you have this cases in insurance law that the insured has not disclosed whether she or he had a certain, disease in the past or undergone treatment in the past, or in the context of, fire insurance contracts, whether there is a lurking danger in a building or, which you're not informed. All these are well-known examples. Then why is that somebody can remain silent? When can you say that in a contract somebody can remain silent? Is there a right to remain silent in entering into a contract? So therefore, unless you answer this question, why then the Contract Act talks about silence and in section 17, and then misrepresentation which borders on silence will or will not vitiate a contract? Because after all, in the formation of a contract, all of us know, depending on the particular subject of a contract or the nature of a contract, there is an information sharing between the parties. We all know as students of law, we studied about whether a horse was a white horse or a black horse, whether a particular building was an old building or a dilapidated building or a good building. We all studied about all those kind of cases. But then why is the importance of a silence? Then when will silence amount to a fraud? So when silence amounts to a fraud making, namely that you want to take advantage of a situation when somebody is persuaded to enter into a contract and you are in silence, that silence will amount to a fraud. You will find any number of English cases from Derry versus Speak onwards, which talks about when silence or misrepresentation can be an aspect which vitiate a contract. So when section 19 read with section 17 talks about it, please bear in mind, these are basically principles. One, a mistake will vitiate a contract. You have the mistake of fact. Then a misrepresentation is what? You mislead a person to enter into a contract by saying A is B and B is C. So misrepresentation. So if A is neither B nor B is neither C, then why would I enter into a contract? So therefore, the persuasion to enter into a contract being so fundamental by reason of a misrepresentation. And the misrepresentation is not, let some say it is, say I did not make an active misrepresentation, I just remained silent. I did not make, say I wrote in my letter of offer or acceptance, this so and so, so and so. I did not do that. Therefore, I did not mislead. So, but when you have an obligation or a duty to share all possible information, which will not only be relevant for the making of a contract, but it will also be relevant for the performance of a contract. Because the making of a contract leads to performance of a contract. If the performance of a contract is rendered, let's say, impossible by reason of your silence and misrepresentation, then certainly, then you owe the responsibility. Then you are your liability. You know, your liability for paying damage or compensation will definitely be placed on that. I think that's how we should look at it. Section 17 and 19, the larger number of cases on section 17 and 19, and then even including marriage contracts. You know, those hilarious illustrations are where you know, marriage contracts are entered into when somebody remains silent about the state of health of a bride or a bridegroom, or the state of the financial condition of a bride or a bridegroom, so on and so forth. Those are very hilarious instances you find in section 17. So silence can be what fatal.
Thank you very much, sir. In which case, I'm sorry, this would, in which case the exception to section 19, which says, which casts a duty upon the insurer
Yes.
to exercise the care of due diligence. Now we go back in a circle to 17, 19, and so on and so forth. What happens is, I had to disclose, I did not disclose, you did not find out. But you had a duty to disclose everything on doctrine of ubrium fide. So
Correct.
this exception turns on its head. If we go back to 17 and then come to 19 again. In that context, this is a circle. That's why I get a little confused. So
no,
how do you break this chain?
The question is first the generalities of a contract, then specific insurance contracts. That's how we must proceed. So in the generalities of a contract, what is fraud? Whether silence will be a fraud. You find section 17 talks about it, isn't it?
Yes, sir.
For instance, say section 17, you look at the clause 5. Any such act or omission as the law specially declares to be fraudulent. So in the context of an insurance contract, what will be a fraud? Any information relating to your age, relating to your health, relating to so on and so forth, will be a fraud on the insurer. Therefore, there is an omission will be a fraud by you. So the what extent due diligence can be stretched. Of course, the insurers these days have all kinds of possible mechanisms to do due diligence and search. But suppose there is some information which due diligence has not been able to reach. Can you say that, look here, your due diligence is faulty and therefore I'll still take an advantage of my insurance contract? I think the court will probably decline it. Unless the act or omission is not fatal to the contract. That's how it has to be seen. Because after all, ultimately, the balance between what I must do and what the other person must do. Forget about section 17 and 19. Ultimately, if you want to fall back on these principles of good faith and fair dealing, in the formation of a contract, what do each party do? I want to achieve a particular purpose or an end. I want to have a certain property sold. I want to, let's say, send a shipment of goods to be sent to Japan, right? And so I have all kinds of things to be achieved by each and every one of us. But then the other party only pays for what I supply. Other party only pays for what service I render. So the question is our mutual duties and obligations, our mutual expectations, each one of us will have to perform, on good faith and fair dealing at both stages, namely in the formation of a contract. That's why whether all those principles in misrepresentation, mistake, fraudulent, fraud, etc., then unconscionability, looking at unconscionability. So why do you say an unconscionability at a contract is void? Our courts have looked into unconscionability in the context of employment contracts. Termination which will be unfair, right? There can be unconscionability when, for instance, in contracts which become impossible, then a performance, then you say a term become unconscionable now. So therefore, unconscionable, that which, appeals to your conscience as something which is unjust. Beyond that, let us not attempt any definition. So all these principles in section 17, 19 ultimately means what? That in the stage of formation of a contract, I said, as the English court said, Lord Bingham, place all your hands up on the table. Place everything up on the table. Nothing shall be concealed. So therefore, if there is something which is concealed, then don't say, oh, you did not know how I concealed it. You can't have a defense like that. Even though, technically speaking, you may probably stretch the other party to do the what's called in Sales of Goods Act, caveat emptor. We all know the caveat emptor principle. So can you stretch it beyond a point? So all that which can be visually seen, caveat emptor applies. That which is in the secret chambers of your mind, right? And how do you really enter the secret chambers of your mind? Therefore, silence can become fraudulent in those circumstances. That's how the courts will look at it.
Thank you, sir. Saurish Mohan Mitra, please unmute yourself and ask your question live.
Thank you so much. Sir, good afternoon.
Yes.
I had a question with respect to some of the contracts that we in our company enter into. Our contracts are sales contracts where we sell our services, which are mainly subscription-based services. And usually there is no termination for convenience clause in our contracts because of the fact that if a subscription is given, then the database is available to the client who buys it, so they cannot terminate that at any point of time. However, there is a clause for termination for material breach if the breach is not rectified within a certain period of time. And we have generally upfront payments. So the payment terms are, say, at the beginning of every year. So in case the contract is for more than 1 year, say 2 years or 3 years, we have 2 or 3 payment terms. So each starting at the beginning of the first year and at the start of every year of the contract. Now, we have seen a lot of instances where after the first year comes to an end, and it is the time for the client to pay for the second year at the beginning of the year, they come back and say that we want to terminate. And they not always come back and say that this is for material breach or anything. At times they do contest services, etc., which we have to always, obviously, we counter everything else. But they willfully, they try to terminate the contract at the end of the first year, and they don't want to pay for the going forward years, saying that, and the typical defense which they take, that there has to be a termination for convenience, and we tell them that you've signed a contract which it clearly says that there is no such clause and you cannot invoke it. We get on to normal contract dispute discussions and other things. But my question was that, is it allowed under our courts to have such a clause where there is no termination for convenience? And at the end of the day, if it is there and the contract, the other contracting party has signed such a contract, can they take the defense later on that that is not permissible?
Well, no, let's go to the fundamentals of a contract. Once a contract is formed, the terms are sacrosanct. No party can deviate from the terms of a contract. But if there are difficulties in the understanding of the terms and they are practical implementations, then the question arises whether unilaterally somebody can go back on the contract. If unilaterally go back on the contract, unless, again, if the terms of the contract provides for a certain contingency where I can avoid the performance of a contract, that will be a different situation. Therefore, from within the contract itself, there may be reasons why a contract need not be honored at all. That's one of the basic principles of a contract. From within the contract, if the contractual performance becomes such that it need no longer be honored, that's a different situation. But there's nothing like a convenience termination in contract like this, because once you're bound by a contract, then you are bringing in an external principle for termination or avoiding the performance of a contract. So bringing in any external principles such as my personal understanding of the need to continue with the contract, my personal benefit or profit or lack of it from continuing with the contract cannot be reasons why I can go back on the contract. That's very clear. And but I do not know why such contracts do not really provide that terminations or such premature avoidance of contracts by themselves would be matters for liability. I don't know why contracts do not provide for that. If they provide on those terms, so what's called premature avoidance of a contract for reasons which are purely subjective and not traceable to the terms of a contract will certainly be questionable. So I think we can provide for those terms. And I say, as I said, subjective, avoidance of a performance of a contract is always illegal. Unless you're able to show that the term of a contract enables me to avoid it, the term of a contract in its enforcement has become unjust and unconscionable, so on and so forth. Otherwise, I don't think any party can simply say it is convenient for me to leave the contract.
Thank you, sir. I'm seeking your permission, Mr. Venkataramani, to extend the webinar by 15 more minutes. I know we've already overshot by time, but in the interest of questions that we're receiving, may I please extend the webinar duration for another 15 minutes?
All right.
Thank you.
Provided I'm able to answer these questions.
Mr. Anup Garg, please unmute yourself and ask your question live. Mr. Anup Garg, please unmute yourself and ask your question live. Over to you, Mr. Kumar.
Okay. Sir, I'm getting a very interesting question. Not contracts, but mostly in political science. Professor Madhukar Sharma has said that it is said that I have a social contract with state. So why am I not allowed to rescind this contract? State will only allow me to rescind this social contract if I am seeking citizenship of some other country, not otherwise. So not in the context of contract law, but definitely in political science. So he just wants to know your view on this, sir.
Why do you bring in Rousseau into all this, right?
It's just an interesting question that has come, so I thought I should put it.
Let me try to answer. I don't think there is any place on the globe where we can avoid a social contract and go away from a social contract. I think our planet Earth has been designed to have a social contract for human beings, right? We cannot. And then you may say, all right, can you say that I don't like the Indian Constitution? I think I prefer like the US Constitution. I prefer a Chinese Constitution. Well, you may personally prefer any one of the constitutions. But then that doesn't make give you the freedom to contract out of the Constitution. So there's nothing like a contracting out of a constitution of a country. You can contract out of a law. Contracting out of a law is possible provided, again, your waiver, etc., are not inimical to your own interests. And you with full knowledge, you waive certain, positions in your life. But there's nothing like contracting out of a constitution. I wish if at all it happens like that, I think our public places, including India Gate, like Hyde Park, will become places for 24 hours of contracting out of the Constitution. I don't know, but it's an interesting question. I will reflect on it. We'll come back on it. We can probably have it as a webinar discussion subject by itself.
Definitely, sir. The books are written on this, and that's the only reason why I asked. May I now invite, thank you, sir, for this lecture. May I now invite my teacher, Ravandle, to come and say a few words on today. We don't have any more live questions.
As usual, this was one more wonderful session which you have delivered. I still remember the sessions you delivered on campus as part of the constitutional law series, and wherein the titles of those sessions, which were devised by your good self, were so intelligently done. And when the discussion was taken forward, people rather realized this was another aspect of constitutional law which never was discussed. And today's session, though the term nowadays fairness has been into media for different reasons, but fairness has not lost its origin and has always been practiced. And when you coupled it with good faith, so has been seen by the private law, then public law. And then we see on the basis of the seriousness of a wrong, it always has proven or has made the distinction between the innocent and the right ones. vis-a-vis the ones who have violated. And today's session makes us realize the importance of research, because I was seeing the lots of comments which were coming in that it was so well researched. Rather, I say, because this is a session delivered by Mr. R. Venkataramani sir. So it never would be research one, rather it was beyond research. And the topic which was so created by, it was done by Mihir. Mihir came up with this topic and then he said, I read these articles and I think sir is the right person who can speak on this. And he was explaining to me the dialogue which was taking place, or the interaction taking place between you and Mihir. Because then he was telling me that you have started reading so much on this topic itself. You have referred to several of the books and the articles, and we were looking forward to. And I could see the kind of questions which were raised. They talked about it. So be it the social contract, because something which always has attracted our attention as a student of law, that the relationship we have as subject with the state. But when it comes to the private law, because as far as I go, I see contract as a private law, and it is always the relationship between individuals, or maybe individual and organization, etc. So it never has that ramification that of a public law. But at the same time, we find the presence of it and the liability on the part of the state when we refer to the Constitution of India. So it is so well developed. So not just social contract, but we also can see that it is so imbibed into the document, which rather creates what we call as ourselves as a Union of India. But again, we cannot forget that it begins with the term "we the people of India." So it is not the state, but we the people of India who create and who stand for it. So it was also another question. But thank you very much, sir. And as you promised, we surely will have a session on whether one can get out of the social contract, whether it is social. And then, of course, one can have reference to several principles which you find under the preamble as well. Because when we call ourselves as, so therein different words are phrases are used, terms are used, statements are made, and they have relevance, not then, but today and tomorrow as well. So I would not say much on the contract part, and it was a good learning for me today. And I could see, because the point which I like most, like that contract is an inherent part of our life. As you begin or you end, it's a contract. And that was the line which I liked. And when you address a situation, you said it very correctly. You don't have to refer to pandemic. You have to refer to the terms of the law as applicable at that time. Situations keep on changing, but law does adapt to the changes because it is very dynamic. And that is what I always have liked about you. And it always has been a great learning. And I'm always proud that I'm also one of your students who has been learning through your teachings. Thank you very much, sir. Over to you, Raj Kamal.
Thank you so much, sir.
Raj, can I just have half a minute? I thought I have some concluding remarks which I thought I could still say. No problem, no?
No.
I'll just read them.
You're the one, sir.
Yeah. Now, we are talking about filling the gaps of all these by, good faith and fair dealings, etc. So there are those who preach the sometimes discarded principles of economic efficiency, the implementation of communitarian values, the inference of norms implicit in the parties' relationship or implicitly consented to. It cannot be said that the legal system has adopted any of these criteria as exclusive. That's one statement about good faith. Then I came across this statement also. There's a study which found out that between 1985 to 1994, the implied covenant of good faith has found in more than 10,000 cases in US. And therefore, unlike other implied law terms, the good faith, let us say, need not be a default concept which can be used to fill only one particular sort of omitted case, but as an overarching principle which can be properly waded into the whole fabric of contract law.
True.
Thank you.
Thank you, sir. Thank you. Now I invite my friend Raj Kamal to give today's vote of thanks. Raj, over to you.
Thank you. Sir, on behalf of the organizers of Knowledge Series on Law and Justice and all the participants, we thank you for gracing the occasion and delivering such an intense, erudite, and thoroughly researched lecture, which has enlightened our mind. We feel privileged, sir. We would like to also express our deepest sense of appreciation towards Lex Witness, THS the law firm, Sadgamaya, and Symbiosis Law School, NOIDA, led by our director and our mentor, Dr. Professor C.J. Ravanle, sir, for providing such an amazing platform to learn from the legends in the legal profession. I would also like to thank my colleague, Mr. Kumar Mihir, for moderating this session so well. To all the participants, we'll be back next weekend with few more eminent personalities and authority in the legal profession. We will forward the registration links soon. For those who missed certain portions of today's webinar, the video is available on the YouTube page of Symbiosis Law School. Thank you.
Okay.
Namaskar. Thank you. Thank you, sir.